We now turn to that part of the conference that really gets you your CLE credit. Let me ask, how many people here are lawyers? Please raise your hand. Take a look around the room. All right, so that's about 2/5, I would say, of the room. So both Marcy Hamilton and I will be addressing for the next 40 to 50 minutes, followed by questions that you can ask of us, and the microphones are here, about the constitutional, and we have to add statutory law that governs the territory of landmarks and historic district preservation. Marcy will be dealing particularly with the statutory evolutions, which really follow on constitutional law, and she'll describe how that transformation actually occurred. I, however, will be dealing with straight constitutional law that governs historic preservation, and in particular, the takings or just compensation clause and the due process clause of the United States Constitution, and there are corollary state constitutions as well. All of this comes about because landmarks laws, and New York City's is of course no exception, control the use of property. And they restrict individuals in their use of property, and depending on who the individual is, they may restrict certain kinds of constitutional rights. The big issue that has been the big issue for all sorts of landmarks, not just religious, and not even nonprofit, although it can apply, but particularly for private owners, although it applies beyond that, has been this notion that when you are designated a landmark or find yourself in a historic district, all of a sudden value has been taken away from you. Part of your private property has been taken away from you, and there are arguments about that. And the arguments have been situated under the just compensation or takings clause, which is lodged in the Fifth Amendment to the United States Constitution, and states, "Nor shall private property be taken for public use without just compensation." And sometimes there's a comma before without just compensation, and sometimes there's not. It's not clear, by the way, whether that comma was just an imperfection in the document and not a comma, or whether it was a comma. Believe it or not, that's a controversy, which could have some consequences, but not for us. Now, the purpose of the just compensation clause has been stated by the United States Supreme Court, rather than just our founders. And that purpose is to assure that individuals, including landmark owners, do not bear burdens that in all fairness and justice should be borne by society as a whole, by all of us. So I'm designated a landmark. Why should I have to bear the costs of this wonderful landmark? I think it's a great thing, but all taxpayers should have to pay for it. Everybody, not just me. Why picking on me? Now, the just compensation clause has been most understandable in the context of eminent domain, where a government formally, expressly, openly announces to the owner, we are taking your land for a highway, for a park, for a reservoir, or for whatever. It's for a public use, a public purpose, and we're going to pay you compensation. No problem, everybody understands that. Although there's even controversy there, and the Kelo versus City of New London case from 2005 demonstrated that even there, it's not so easy. However, what about a so-called regulatory taking, where government is not formally exercising its power of eminent domain, but is simply enacting regulations, and simply is the key word, zoning and landmarks? Well, back in 1922, Justice Holmes in the Pennsylvania Cole versus Mahan, or Mahon case, people, by the way, announce the pronunciation of Mahon or Mahan as if they really know. I don't think there's anybody alive who knows how that last name was actually pronounced. We could actually track the family through. In any event, he issued this very, very famous statement that, quote, if a regulation goes too far, it will be recognized as a taking. Aha, finally we know what is a regulatory taking. If it goes too far, it's a taking. Well, that sort of crude technology of an expression had governed the country and the constitutional law affecting land use regulations for many, many years, until the Penn Central Transportation Company versus New York City case in 1978. Yes, Goldblatt versus Hempstead, actually a New York case, but at the Supreme Court come along and said a few things. But in fact, we were governed more or less by this statement from Justice Holmes of goes too far. Then in 1978, Penn Central, and then the floodgates opened. Agins, San Diego, Loretto, Kaiser Aetna, Williamson, McDonald, First English, Keystone, Nolan, Pennell, Yee, Brasalt, Lucas, Dolan, Sudum, Del Monte, Palazzolo, Tahoe Sierra, Chevron, and Kuntz. That's the takings 21 if you're counting. And those all come from the United States Supreme Court. Now, you earn your CLE credit if you know all 21 of those cases. But now I'm going to give you a little secret, which is actually, and this is something of an overstatement, but CLE is an overstatement anyway. You really only have to read the Penn Central Transportation Company versus New York City case. As I said, it's an overstatement, and you can quote me, but then you have to quote the qualification. And that's because it really still more or less governs in its imperfect way how we think about regulatory takings in the United States, and in particular with regard to landmarks preservation. And it's, of course, near and dear for anybody in landmarks preservation because the facts of the case, the law at issue, is not a zoning law, it's landmarks preservation. And indeed, it's this very law that we are marking today in its 50th year. So let's go through the case. If I were in another state right now doing another CLE program, I would be talking about this case with regard to landmarks preservation. And interestingly, the law in that state locally dealing with landmarks might be very, very similar to New York's law. New York's law has been copied nationwide, with changes to be sure in different places, and we'll hear with national practices later this morning about some of those changes. But interestingly, New York's law dominates in many structures and cities. And the reason it does is not just because of the brilliance of the law, the way it was drafted and put together. New Yorkers might argue that's the reason, it was just so great. But in fact, it's because the Penn Central case became a wholesale Johnny Appleseed, in which people read the Penn Central decision, saw what a landmarks law looked like, saw that the US Supreme Court upheld its constitutionality and said, if we do this, we're constitutional. So it has actually been enormously influential, strictly and largely because of the Penn Central decision. So the law is there, and it's described in the beginning of the opinion by Justice Brennan and his 5 other colleagues. It was a 6-3 decision. So the facts of the law, of the case, indeed, lay out the landmarks preservation law. We've heard about it already a little this morning. There's a Landmarks Preservation Commission, landmarks, historic districts. They designate, and if you designate, essentially, you're stuck with going to the commission to get permission to do just about anything. All right? Now, there are outs from this, the so-called certificates. There are the certificate of no effect on protected architectural features, and there are these 2 certificates of appropriateness, one for appropriateness, okay, it's appropriate, and the other for so-called insufficient return. So the US Supreme Court, in its opinion, lays that out and finally mentions something which is particularly relevant today, which is the use of so-called transfer of development rights to landmark sites. That's, by the way, in a different law. It's not in the landmarks law, it's in zoning, but it affects, of course, landmarks, and it talks about those sorts of transfers. So the opinion lays out the law, and then it states relevant facts to New York City's situation. At the time of the case, and we just heard a wonderful narrative historically from Sarah about where we were. Well, at that time, there were over 400 landmarks and 31 historic districts designated. Penn Central owned Grand Central Terminal, the wonderful 1913 Beaux-Arts facaded structure that we all know and love here in New York, along with 8 TDR, transfer of development rights, eligible sites. In 1967, the Landmarks Preservation Commission designated Grand Central Terminal. We're not going to have another Penn Station debacle, and Grand Central Terminal was indeed designated. 1 year later, Penn Central entered into a deal with a developer, a 50-year renewable lease and a sublease for the developer to construct a tower essentially above the terminal. And indeed, Marcel Breuer, the great architect, designed two possibilities for towers above. One kept some of the terminal, one got rid of most of the terminal. So one was more like the Villard houses, one wasn't. In any event, both were turned down in terms of appropriateness by the Landmarks Preservation Commission. And that's what brought the case finally to the United States Supreme Court after it worked up through the state courts. So what did the US Supreme Court say? First, the Landmarks Preservation Law substantially advanced the city's legitimate interest in historic preservation. We heard a little bit about that earlier today, but here was an authoritative statement that landmarks preservation, that sort of goal, would suffice to uphold a law generally. This actually sounds more in due process than than the takings clause. I mean, it's a public use idea in the takings clause context. But in any event, the court said cities can exercise their authority to advance historic preservation. That's part of the quality of life of cities. It's a legitimate purpose. It's part of the health, safety, morals, and general welfare for which governments can reasonably enact laws. Okay, terrific. We can breathe easy now. We can do historic preservation. But that's not the famous part of the case. The famous part of the case is, well, what do you do when a law diminishes the value of property, perhaps even significantly? And the court said in its key holding, looking at the first, economic impact upon the claimant, second, the interference with the claimant's distinct investment-backed expectations, and third, the character of the governmental action, the Landmarks Law, as applied in this case, did not affect the taking of property. This leads to the articulation of the so-called three-factor inquiry or three-factor test. Anybody who knows takings should be able to articulate it. Economic impact, interference with distinct investment-backed expectations, and character of the governmental action. That's what Penn Central is all about. Now, of course, that is not a formula. It doesn't say if you deny 90% of value, it is a taking. And indeed, the court expressly, almost sheepishly admitted at the beginning of its opinion that we have not been able as a court to develop a set formula. This is an ad hoc test. It'll be case by case applied by judges. Sorry, we can't do any better. This is an intellectual conundrum, and that's the best we can actually do. So we don't really know how much economic impact, how much interference with distinct investment-backed expectations really will suffice to have the regulation, as Justice Holmes said, go too far and suddenly be classified as a taking rather than a constitutional exercise of government power. The court, however, did help us out. It applied its three-factor inquiry to the facts of the actual Penn Central case. And it cited what led it to decide in favor of the government. First, Penn Central admitted that it earned a reasonable return on its primary expectation, to wit, the existing terminal itself. This may have been a legally strategic blunder on the part of Penn Central. They admitted it in the lower courts. But the US Supreme Court seized on that and said, look, yes, you are being denied literally millions of dollars, which the lessee would pay. The developer would be paying Penn Central millions of dollars a year. No question about it. You're losing that because of what the LPC has done to you. But that wasn't your primary expectation. So that's not a sufficient economic impact. Are you kidding me? Millions of dollars? Not a sufficient economic. Are you kidding me? Not an interference with distinct investment. Your distinct investment-backed expectations were the terminal. Don't tell us about that you plan to build in the air rights above and earn millions of dollars a year. Second, Penn Central's ability to transfer development rights to at least 8 surrounding parcels created values. And these development rights, and now I'm going to quote because this is very relevant, as some of you may know today. These development rights, quote, are to be taken into account in considering the impact of regulation. So if anybody ever tells you that without TDR you can't do landmarks preservation, that's not coming out of the Penn Central case. But if anybody ever tells you that they're completely irrelevant, you could say, well, they do talk about having these things taken into account, at least in the New York case. So they're helpful, and of course, Why not have them? The third key element of this sort of reasonable return on existing use, development rights being helpful, was this notion of the parcel as a whole. And this is quite interesting. Penn Central wanted to focus the court's attention on the air rights, claiming that 100% of the air rights were taken by the landmark designation. And the city came back and said, don't focus just on the air rights, look at the air rights and the existing terminal. And when you look at the package together, then there is money coming in from the terminal. If you just look at the air rights, to be sure, you're wiped out. And the court adopted the language of parcel as a whole. When government zones a parcel and says you have to set back for the first 20 feet, you can't build in the first 20 feet of your parcel. It's 40 acres of land and 39 of the acres you can build on, but you can't build on 1 acre. Wetlands, same sort of thing. There's 1 acre of wetland out of the 40. The property owner comes in and says, you've taken 100% of the 1 acre. No, we look at the 40 acres, everything, and see whether or not you have an economic return on the entire thing. Don't look just at the air rights above a landmark. Look at the entire parcel as a whole. Very, very important. Fourth, the court mentioned that the landmarks plan, landmark designation was pursuant to a plan, so it had indicia of comprehensiveness. Justice Rehnquist in dissent said, this is preposterous. This is the example, the epitome of illegal spot zoning. But I guess the US Supreme Court found some sort of plan. We can question and wonder about that, but there had been some sort of thing. And finally, fifth, the court said in a prescient invitation, which is now sort of being taken by the owner of the Grand Central Terminal air rights today, Penn Central or the owner can always reapply to the courts if there is a problem in the future. And the problem is now the present. So, what's happened since Penn Central? Really not that much. I mean, I mentioned 20 other cases post-Penn Central. And yes, we have a clearer statement of what constitutes a regulatory taking. Lucas versus South Carolina Coastal Council from 1992 tells us that if you wipe a property owner out completely, if you deny the owner all economically productive, beneficial, feasible, or viable use of the property, and I don't use those adjectives lightly. The US Supreme Court in the Lucas case used all 4 adjectives, beneficial, feasible, viable, all of those adjectives in its opinion without saying is beneficial different from productive, different from viable, different from feasible. But if you wipe somebody out completely, it's probably a taking. The US Supreme Court couldn't even say in the Lucas case that it absolutely was a taking, but it indicated that probably will be your paradigmatic takings case. So we now know, leave some economic value there. So you get 2 bites at the apple. Demonstrate a complete wipeout, which is hard to do with a landmark, or you're thrown back to Penn Central and it's non-specific, no set formula, ad hoc, 3-factor inquiry. By the way, I haven't said anything about character of the governmental action, the 3rd factor. Why haven't I said anything about it? Because I really don't know what to say about it. The US Supreme Court didn't know what to say about it either. It mentioned one bad character, which would be if an ordinance authorized a physical invasion of property, that would be bad character. But it didn't say anything else about what character of the governmental action might lead to a finding of a taking. You know, what's bad, what's good. So we really don't fully know. It hasn't been ever fully fleshed out. Okay. I mentioned that there is current controversy related to Penn Central, and indeed there is. The Midtown TDR Ventures LLC versus City of New York case. This is wonderful. This is the plaintiff. The plaintiff is now legally known as Midtown TDR Ventures LLC. That's a New York State limited liability company. I mean, it's terrific. They set it up that way. And Midtown TDR Ventures LLC owns Grand Central Terminal and the air rights, which are still unsold above the terminal, more than 1.2 million square feet. Some air rights have been sold in the past. And they have sued recently the City of New York, claiming, among other things, a taking. They wanted to sell some of the 1.2 million square feet to a nearby property owner across the street, a property between 42nd and 43rd Street, right on Vanderbilt Avenue and Madison Avenue, that block front. And the city recently has rezoned Vanderbilt Avenue next to Grand Central Terminal, allowing owners of sites, including some of the potential receiving sites for transfer of development rights from Grand Central Terminal, to obtain what's called a public realm improvement bonus from the city of New York. That's just fancy language for saying that the owners of these parcels can get air rights from the city of New York, effectively from upzoning of their parcels. So right now they can build at what's called a 15 floor area ratio. If you don't know that, don't worry about it. But they can double their development, but they don't have to buy the air rights from Grand Central Terminal. They can buy them from, effectively, the city of New York. Now, we don't say they buy them from the city of New York. They are going to provide wonderful infrastructure and pedestrian improvements, infrastructure improvements. And in return for that agreement, they will double the floor area that they would otherwise have been allowed to develop on their site. And guess what? The owner of Grand Central Terminal and the owner of those air rights is now competing, he says, it says, but it's a he, with the city of New York, and has claimed a variety of things. He says it's private zoning. The city is now taking, air rights that he owns and giving them to an adjacent private owner through zoning. But he also claims a taking. He's been wiped out completely by this exercise, and he wants $1.2 billion from the taxpayers of New York. He makes some other claims as well of collusion and all sorts of things. So this is a very live kind of case. It's interesting. One should read the Fred F. French Investing Company versus New York City case, which was a New York Court of Appeals case, which deals with transfer of development rights back in 1976, dealing with a city zoning provision that was struck down, and that zoning provision limited transfer of development rights from two parks at Tudor City here in New York, and said, we want to preserve those parks. We'll allow the owner of Tudor City at that time, Harry Helmsley, to transfer his development rights that otherwise could be put on those parks, transfer to anywhere in Midtown. And the New York Court of Appeals struck it down, claiming that the economic value of that transfer was sufficiently uncertain as to make this an unreasonable zoning provision under, by the way, the Due Process Clause, but it really is under the Takings Clause. He says, in the opinion, there was thus created floating development rights, utterly unusable until they could be attached to some accommodating real property, available by happenstance of prior ownership, or by grant, purchase, or devise, and subject to the contingent approval of administrative agencies. In such case, the development rights, disembodied abstractions of man's ingenuity, float in a limbo until restored to reality by reattachment to tangible real property. Hence, when viewed in relation to both the value of the private parks after the zoning and the value of the development rights detached from the private parks, the amendment destroyed the economic value of the property. It thus constituted a deprivation of property without due process of law. And he really meant without, under the Takings Clause, but he was a due process guy at the time, Chief Judge Breitel. Okay, so that's where we stand on takings. I'm going to say 1 minute on due process and then turn it over to Marcy. The Due Process Clause, relevant, interesting, but not really relevant nationally and not in New York State. Here, we're dealing with this notion that laws that are arbitrary and capricious, having no substantial relation to the health, safety, morals, or general welfare, are unconstitutional under the Due Process Clause. For purposes of historic preservation, mostly the claims are void for vagueness claims, in which the claim is made that the criteria under which landmarks and historic districts are designated are too vague, are too ambiguous. The reasonable person would not be able to understand them. And in fact, there were a series of cases out of Chicago and the Illinois state courts, Hanna versus City of Chicago, 3 particular opinions, in which the plaintiffs alleged that Chicago's ordinance was unconstitutionally vague and ambiguous in violation of the state's Due Process Clause. And in a 2009 opinion, the Illinois Appellate Court held, we believe that the terms value, important, significant, and unique are vague, ambiguous, and overly broad. We are unpersuaded by the city's arguments that the commission members can be well guided by these terms. They also questioned the qualifications articulated for the commission members being vague. There are, quote, no criteria by which a person of common intelligence may determine from the face of the ordinance whether a building or district will be deemed to have value or importance. So they sent it back down to the trial court. The trial court literally pulled out a lot of dictionaries and said, no, actually these terms are not unconstitutionally vague at all. It went back to the exact same court and they said, you know what, you're right, they aren't. And so that's where we stand with due process. Look, it's Illinois, what do we care about Illinois? But that's the sort of due process kind of analysis. So let me now turn over the dais to Marcy Hamilton to hear on the religion side. Thank you.
Thanks very much, both Professor Caden and to the Landmarks Preservation Commission for inviting me to be here today. This is the 50th anniversary, but for the story that I'm going to tell, it's really the 25th anniversary. So let's go back to 1990, and in 1990, I was clerking at the Supreme Court for Justice O'Connor, and the Supreme Court decided Employment Division versus Smith. This was the peyote case. I can tell you not one person in that building thought that case meant much at all. None of the clerks were fighting to be on it. No one thought that it was changing the world. What we didn't really understand, though, is that when the Supreme Court announced that the use of peyote is not a protected activity under the First Amendment, what the court was actually doing was that it was rejecting a standard that had been requested for 25 years. So it's not that the court changed anything in 1990 with Employment Division versus Smith. Rather, it's that they finally definitively said, no, we are not going to use an extreme standard. And so the response to that was, well, if the court won't do it, let's have Congress do it. We'll go talk to Congress about the Religious Freedom Restoration Act, which we now have at the federal level and in 20 states. But in the era when the First Amendment was the governing law over these issues, we had the St. Bartholomew's case. And in that case, the question was whether or not a building that was adjacent to a house of worship could be taken down and replaced with a 50-story office tower. And the argument was that they had a religious liberty right to be able to do that because they needed the money, number one, and number two, they'd be able to do a lot more mission if they were able to get the money from having an office tower rather than just from having what they had. And they were denied under the reasoning of landmark and historic preservation. The Second Circuit, and the Supreme Court didn't take up the case, so the Second Circuit was the final word, said, well, actually, under the First Amendment, if the law is neutral and it applies to everybody the same, which the landmark law did, there is no special First Amendment protection. You don't get free exercise rights on laws that are neutral and generally applicable. This law is, and therefore it is perfectly constitutional. They also raised a Fifth Amendment issue, which was just as easily and even more quickly disposed of. But that is the rule under the First Amendment, and it is still the rule under the First Amendment. If you have a zoning law, if you have a landmark law, historical preservation law, and it is neutral, in other words, it's not discriminatory toward a religion or religion generally, and it's generally applicable, it applies to everybody who does exactly the same thing. In that circumstance, the First Amendment does not protect the religious believer from having to abide by the law, right? You know, my favorite example, which is about as simplistic as you can get, is, I was late one Sunday driving to church, and I ran a stop sign, and a policeman stopped me. And I said, well, hey, I was going to church. And he said, I don't care. And he was right. I didn't have a First Amendment right to run the stop sign just because I needed to get to church. That law applied to me regardless of my beliefs or my religious needs. That was the universe that we all lived in up until 1993. In 1993, the Supreme Court decided Churchill-Lukumi Babalu-IA, which was a Santorian case, and the court said, well, if there is a law that is passed just for the purpose of gerrymandering a religious group and getting rid of them, which is what City of Hialeah was trying to do to the Santorians, now that would be subjected to strict scrutiny. And in that case, the court said that a law that banned sacrificial animal slaughter, but let every other kind of animal slaughter go forward, that was subjected to strict scrutiny, and that was unconstitutional. 5 months later, RFRA was passed. So the Religious Freedom Restoration Act was put into place in 1993. RFRA is a radical standard that had never been used at the Supreme Court for any free exercise case ever. What RFRA says is that a law that substantially burdens someone's religious practice is going to be legal and applicable only if the government can prove it has a compelling interest, and that compelling interest is served in the least restrictive means for this believer. It is lawyers' doublespeak. It's constitutional standard. It's the only statute in American history that is nothing but a constitutional standard taken from the Supreme Court, taken over by Congress, and then Congress says back to the Supreme Court, you applied the wrong standard. Here's the right standard in the cases that you're deciding on free exercise. To give you a sense of how the First Amendment has now disappeared from the picture, the Roberts Court is celebrating their 10-year anniversary, and we just had a conference at Cardozo, so I had reason to go and count cases. And of the free exercise cases that the Roberts Court has taken, not one has been a First Amendment case. 3 have been either RIFRA or Religious Land Use and Institutionalized Persons Act, RLUIPA, I'll talk about in a minute. But they've taken 6 Establishment Clause cases, all for the purpose of narrowing the separation of church and state. So right now, we have a statutory universe in which the issues that you care most about are being governed. So in 1997, I represented Boerne, Texas at the Supreme Court and argued RFRA was unconstitutional. It was an extreme standard that had never been used before, and we won. Now that case is a prime example of what's wrong right now with the RFRA RLuIPA universe. That case started with a small church, relatively small, in a small historic district in Boerne, Texas, outside of San Antonio. And it wasn't as old as things are in Philadelphia, where I live, or in New York. It was only 70 years old, but this was where they have their antiquing district. And so they went in and they said, the church said, we want to demolish the building and replace it with a box. And it was a beautiful, beautiful building. And so the response from the city of Boerne, the mayor, who was a Methodist minister, said, no, you got to keep the front, keep the facade. And so they went into negotiation. And as you can imagine, what was the negotiation? What percentage of the front would be preserved? 30% or 70%? And the idea was that it would look identical from the street as part of the historic district, but behind it, they could do just about anything. So they're negotiating, and as you can imagine, there's a middle number between 30% and 70%. That's what happens in negotiations. And so they're negotiating, and RFRA was passed. The church says, no longer are we going to be negotiating with you because you can't enforce historic preservation law against us. We are invoking RFRA, and we're going to federal court with RFRA. So for several years, there was litigation over RFRA. The ultimate outcome was that the Supreme Court said that RFRA was unconstitutional. So there was no more RFRA. So RFRA walks out the door, and what do you think happened? Everybody sat down at exactly the same table in Boerne, negotiated, and preserved a significant percentage of the front of the building and built an addition. It is a beautiful new addition. But it was RFRA that derailed it the normal process of negotiating and talking. And that's what's happening right now with the Religious Land Use and Institutionalized Persons Act. So after RFRA was held unconstitutional, we didn't have one anymore, and so it looked for a moment that it would not be reenacted, and the civil rights groups had finally figured out that the primary purpose for the original RFRA was to overcome the fair housing laws, to keep unmarried couples out of apartments owned by certain religious believers and to keep gay couples out. And so when they finally figured out really what the agenda was from the beginning, they started to talk against it. And actually, RFRA 2 was going nowhere. Then in 2000, there was an agreement. A deal was cut. There would be a RFRA for federal law, and then there would be the Religious Land Use and Institutionalized Persons Act. So in other words, land use in prisons would be, it's the original sausage that you see coming out of legislatures. So RLUIPA, which, and the reason I know how to say it is because when it was going through, those of us opposing it, someone a lot cleverer than I am sent around the Taco Bell dog, and it said, the Taco Bell dog says, drop the chalupa, and so it was drop the RLUIPA. So, which was the only win we had because it passed. So this is a law that passed by unanimous consent after they called recess on July 27th, 2000. And the opposition had no idea it was going to be voted on, and the membership brought it up, and unanimous consent is you need a couple of people present. And they hired a messenger to take the bill from one house to the other to make sure that it would not fall apart in the middle, and they passed it in record time. So what does RLuIPA do? RLuIPA says that for land use purposes, any religious entity that wants to build or apply for any kind of building has a special privilege. If the local land use law imposes a substantial burden on them, you can't apply that law to them unless it serves a compelling interest and the least restrictive means. Now, for anybody who has worked for any amount of time in land use, you know that as a constitutional matter, there's very little in land use that rises arguably to compelling interest. And so basically what has happened since 2000 in the last 15 years is an erosion in land use principles and zoning across the United States if it's a religious building that's making the application. And this is how it operates. At first, everyone agreed under the legislative history of RLuIPA that you did have to apply if you wanted to get a zoning change, if you wanted a variance. And the courts actually held in a series of cases that a case wasn't ripe if you didn't. But the tenor that's been taken is the following, and this is now gaining tremendous traction, and it really is the end of zoning of religious entities, and I'm not exaggerating. The argument is this: if there's any discretion whatsoever in the decision-making by the government, that discretion justifies imposition of RLuIPA, and that fact of that discretion means that you shouldn't have to apply. Well, as we all know, historic preservation, zoning, these decisions are made with some discretion. It's guided discretion, but there's discretion. And so the two cases I would bring to your attention are not historic preservation cases, but they are important examples of where the movement is going. Right now in Pomona, New York, I represent Pomona, New York with Robinson and Cole. And in that case, a developer, Chaim Babad, came in and bought 100 acres of single-family zoning. And the purpose for the 100 acres is purportedly to build a rabbinical college, and a rabbinical college needs multifamily housing. So the idea is that the 100 acres would now be used for multifamily housing and for a rabbinical college. What is a rabbinical college? It is a study hall and a synagogue. And so the rest of the acreage would be used for multifamily housing. On the law, we should have won this case from day one because they didn't file a single application. No application was filed for either the educational use, the religious use, or for the housing. Instead, they went directly to federal court. And in federal court, they said that because of RLUIPA, they do not have to abide by ordinary procedures. They don't even have to file an application. They're just going to challenge every law that would affect them as facially unconstitutional. And so we just received a summary judgment decision from the judge. And the most notable part for you is that he held that community character is not a compelling interest. So the character of the community is not a compelling interest. And what that means is that a federal judge has just said that the New York courts that have repeatedly said community character is a compelling interest, that those state court rulings are irrelevant in a federal RLUIPA case. And so if you are a religious landowner, you don't have to be bound by either an application process or by community character. And if community character doesn't matter, the switch from single family to multifamily on 100 acres is not a problem, right? Now, the lawyers in that case are also in another case of mine in Ben Salem. By the way, I don't really take many cases. I only take them if I think that they're so outrageous that I've got to do it as a matter of public service. And then I remember why I don't take cases. So Ben Salem is a fascinating case. Ben Salem, Pennsylvania, Bucks County. So you have two mosques. One mosque buys property that is properly zoned and sails through the process, and they are going to get their final approvals in record time. Another mosque that can't afford that property buys three properties, each one zoned independently, none of them for a house of worship. They then file for a variance. What they need is a zone change, right? You got a three-part split zone property, and you just need a zone change. And they probably would have gotten a zone change if they'd applied for it. But they argue that applying for a zoning change requires discretion on the part of the government, so under RLUIPA, they do not have to apply for a zoning change. Instead, they only apply for a variance. But when they apply for the variance, they say that they don't have to abide by the hardship requirement, which St. Bart's did. They don't have to abide by the hardship requirement because they're religious. And so they go through hearings and they get a denial based on the fact not only didn't they prove that they satisfied the standard, but they refused to satisfy the standard. And we argue they should apply for a zoning change. This is ridiculous. And the federal court shouldn't get into this business of second-guessing the local government on something this easy, zoning change. Well, we filed for a motion to dismiss, and we just lost that. Now we'll be going forward into discovery. And in that case, they're arguing anti-Muslim discrimination in a town where another mosque is sailing through. And they're arguing that they don't have to go through zoning ever. Now, when I first saw this argument, you don't have to go through the zoning process about 5 years ago, I cracked up. I said, how much more extreme can these arguments get? But that is now a standard argument, that a religious entity doesn't have to go through the zoning process. If they don't have to go through the zoning process, you can be certain they don't have to worry about landmarking. And if you think community character is a compelling interest, and the federal courts actually don't, aesthetics in a religious context are not only not a compelling interest, it's almost embarrassing that anybody would be concerned about aesthetics. Aesthetics are for people who have concerns other than religious mission. Aesthetics have never been found to be a compelling interest in the United States. Historic preservation is not a compelling interest. And so to the extent that a religious entity has RLUIPA, which they do right now, even though my view is it's unconstitutional, but you've got to get through a lot of statutory interpretation before you ever get to the constitutional question. If they have RLUIPA, they can argue against the vast majority of what the Municipal Art Society, the National Trust, Landmark Conservancy, all these wonderful organizations have been working on. And so the bottom line is, where are we headed? Before the Supreme Court decided Hobby Lobby, I would have said there was a way to rationally read RIFRA and RLUIPA. It's the same standard, just two different, one's federal, one's state. But after Hobby Lobby, the doors blew off. Why? Because in Hobby Lobby, the Supreme Court said that the least restrictive means is anything we can imagine, whether politically feasible or not. So what was the least restrictive means for the female employees of the Hobby Lobby craft stores to get contraception at no cost? The government would pay for it. The government's not going to pay for it. The government didn't pay for it. And they knew that that was a politically infeasible and irrational choice. But it is less restrictive for the believer. So what RLUIPA does is it puts the focus on the religious entity. Their interests are the primary interests, and the interests of the community are secondary. The interests of third parties affected are secondary. Once the Supreme Court put that interpretation on least restrictive means, we now have a scenario where it is going to be very difficult for any local government, even New York City, to be able to enforce laws against religious landowners. And let me just close with this. The main reason that RLUIPA is the threat it is, which it is a very, very real threat, the reason is because of the attorney's fees provision. RLUIPA says that the city could end up paying both sides' attorney's fees. And so in some litigations, this is what happens. They file the lawsuit, the religious entity files a lawsuit. They've got a denial or they just decide to not go through the process. They then go into court and the city says, excuse me, there's a middle ground here. Well, there's not a middle ground without attorney's fees on the table. There's not a middle ground without thinking about, what it would cost you to litigate against us. It cost you $1 million, $2 million to litigate against us. So a good settlement amount would be $1 million. So in Norwalk, Connecticut, another one of my clients, Norwalk, Connecticut had a scenario where it was a huge building on a tiny lot. No governing agency would have approved this plan. And there was no question on the law that Norwalk could have won. On the other hand, who wants to litigate in federal court for 10 years as a city official? You're not making many friends, and you're making your taxpayers pay a lot in attorney's fees if you're going to have to pay both sides. So the settlement in that case was the following. The group agreed to look for a different piece of property in Norwalk in exchange for $1 million if they agreed to dismiss the lawsuit. And so they received their $1 million, and they are now actively looking for another piece of property, one that is more expensive because they can afford it now. So it's worthwhile following these things, these cases, to understand where we are. But the primary cause of all of this is Congress, to put RLUIPA into place in 2000, and has not reconsidered it. When it was passed, we were promised in 2 years a hearing on its effect, and we have never gotten a hearing. Thanks very much.
So we're going to have time for about 10 minutes or so of questions. The microphones are here, and if you want to come up and ask a question, just come right up to the microphones. In the meantime, I wanted to say, Marcy, it strikes me that you're on the wrong side of all these cases. You should be here. But in all seriousness, for people in the historic preservation business, after your presentation, you almost begin to wonder, are you suggesting that the designation itself of a church or a temple is itself a violation of ReLupa, or the refusal to give a certificate of appropriateness is itself axiomatically a denial of ReLupa? By the way, I don't think it is, but I want to hear what you think.
Oh, no, it's been argued a number of times. Definitely a CO. But in addition, in DC, a church just used it to argue that it shouldn't have to have a bike lane in front of the church.
Okay, so what I would say, and I want to ask you this then, because you see, you're more well-versed in this area, but I would be pushing, and I have seen cases that focus on another two words that you mentioned but didn't stress, which is substantial burden.
Right. And
this issue, remember, the RLUIPA law only applies and only requires the Landmarks Preservation Commission to come back and demonstrate a compelling interest in this designation, which, as you said, virtually you're never going to be able to win on, demonstrating that the designation of a landmark is a compelling state interest, even if George Washington slept here, because, it's just under the sort of,
even if he's still there,
under the double speak of, even if he's still there, exactly, under our constitutional law tests, and this is really for the lawyers, it's just a wildly difficult test to meet. But I would want to show this is not a substantial burden on the owner of that religious institution to have a designate. What's the substantial burden? You can still do your stuff. What's the substantial burden if we don't approve that parking lot that gets only used once every 5 years for a religious event that occurs once every 5 years, like they have in India or something like that, which we'll hear about, or once every year or whatever. What's the problem? And so isn't that where we should be, let me not use the word we, those who are advocates of designation of religious facilities, isn't that where one should push?
Well, we were winning on substantial burden in numerous cases under RIFRA and RLUIPA until the 2000 reenactment, and they redefined religious exercise so that it is not necessarily central to your belief, but anything that has anything remotely related to your belief. So once they expanded the definition of religious exercise, it became very hard to argue substantial burden. But Hobby Lobby also deep-sixed the word substantial in front of burden, because remember, the argument in Hobby Lobby is that a craft store owner is saying he's complicit if the money that goes into his medical funding happens to be used by a woman in secret because of HIPAA for a type of contraception that violates his religious beliefs. This is a new line. The new complicity arguments, that I'm complicit if someone else does something, all of a sudden, substantial burden just doesn't do anything for you.
Right.
So, and the federal courts hate these land use cases generally. They want them to go away. And in my experience, and routinely, they're basically bullying the cities to say, come on, just do something, give them something.
Right. So we have the chair of the LPC here, the general counsel of the LPC, members of the LPC, the commission. Are you saying, as a lawyer, that the next designation they do of a religious facility would allow the owner of that religious facility to challenge under ReLupa the designation, and that the LPC would lose?
Easily. easily. And the reason is this. The argument is that you are hurting my capacity to make future money on this property. You know the St. Bart's argument? That's not an argument that gets traction with the courts. That it is a substantial burden if it's going to reduce the amount of funds that you have for something else. And that's actually coming out of the Second Circuit, where the Second Circuit has said that expense can be a substantial burden.
So let me now push further, because I'm shocked by your answer, quite frankly, and I'm made very, very nervous about it, and I don't actually fully agree with it, but which is good, because we want to have these sorts of issues. But I mean, it does suggest a revolution in the way we think about designation, let alone issuance of certificate of appropriateness. I wanted to ask, let's say again, with a religious institution, they say, God told me to erect a tower, on this community facility or above it, in order to feed the hungry and house the homeless, which, by the way, I think God just called up on a cell phone over here to intervene in our discussion. And as I recall, in the legislative history of ReLupa, there was express language put in by senators that said, we are not talking about uses of religious properties for non-religious, not religious exercise purposes, such as building an office building or a residential luxury condo tower, even though, yes, that money could promote our religious goals, but that's exempted from the law. Do you at least agree that that is exempted from?
Well, it's in the legislative history. It's not in the text of the statute.
I said legislative history,
National League of
yes.
Cities tried to get it into the statute.
Yes.
That was never going to happen.
But would you be less nervous at least about? I want to come away with at least some non-depressing kind of, message.
I got nothing on that.
Nothing on that. All right.
No, I mean, what happens is that as litigants win in one argument, it's a very small cadre of lawyers that actually litigate these for the churches. And they have shared agendas. And one of the shared agendas is to make sure that historical preservation and aesthetics and community character are knocked out as reasons.
Right. Now, I have seen, Marcy, cases across the country where substantial burden has been used to knock out a claim from a religious institution. It just, there's sort of a parking restriction, that's just not a substantial burden on you, or, you can't change your stained glass window. Oh, it's not a substantial burden on you. So I have seen those. Are you somehow suggesting that if I had studied this in the past year or so, rather than 2 years ago when I read those cases, I'd begin to see more of a trend in a direction?
Those are all pre-Hobby Lobby cases. The Hobby Lobby case really opened the door to argue that de minimis burden is a substantial burden. They really wrote substantial out in their interpretation.
Okay, so if I were a newspaper person in this room, I would say here's one of the news stories that emerges out of this in terms of a claim. We would have more time at another event to discuss this in more depth, and it's going to require me to look more carefully at the religious cases a little bit, because I'm surprised to hear this message, but this is what makes life interesting. All right, are there... Mark Silverman he doesn't want any more discussion of this because, LPC is going to lose, I think it's about 15% of its portfolio tomorrow. No, that's a little joke. All right, well, actually we are running right on time. I've got 1 minute left for us, but since there seems to be a call for our next panel, why don't we turn and hear from the national panel? And what this is about, of course, is that New Yorkers can indeed learn from other jurisdictions. So we'll call up the national panel for the next hour, and then we'll have lunch. Marcy, thank you very, very much.
Thanks.